My name is Lowell Thomas. With me is Angela Perez. We're both business lawyers with the law firm of Snell and Wilmer. We hope to discuss some basic objectives from the legal perspective when starting a business. Here are some basic learning objectives which are attached to our presentation. Firstly, we want you to understand the advantages and disadvantages of the different types of entities available for your business and the appropriate entity or entities for you based on your business objectives. Secondly, we want you to understand the most common mistakes that a business owner may make in attracting personal liability with respect to the operation of his or her business. And thirdly, we want you to understand the critical contractual agreements that a business owner should consider at the commencement of any business operations. The agenda today is protecting your personal assets by forming a company, selecting the right form of entity, how to form a company, capitalizing a new company, and what it means to have partners and how to bring them in. We'll also look at some basic agreements every new business must have.
My name is Angela Perez, and I'm going to begin with the basics of starting a company. Now, who should form a company from which to operate their business? We always recommend that every business owner form a company in which to operate their business. And on a related note, we never recommend that you set up a sole proprietorship or a general partnership. The reason being, by setting up a company, you create a layer of separation between you and the business enterprise. Whereas in a sole proprietorship or a general partnership, you don't have that layer of separation. Now, why do we think it's so important to have that layer of separation? Principally, it's to protect your personal assets from claims. Now, as a general matter, corporations and LLCs are treated as separate legal persons, which are solely responsible for their debts, and they're the sole beneficiaries of whatever credit they're owed. In which case, as a general matter, your personal assets as the business owner are not at risk relative to the activities of the company. But there are some important exceptions, some caveats that you should be aware of, and some mistakes that you should avoid. In order to receive the benefit of this general principle, there are certain mistakes that owners need to avoid. Those mistakes can cause a creditor to look through the corporate form and actually attach personal liability to your own assets. And when a creditor is permitted to hold owners liable for the debts of the company, the creditor is deemed to have pierced the corporate veil. So what kind of missteps can lead to a piercing of the corporate veil? I'm going to be addressing three principal missteps. The first is ignoring corporate formalities. Now, as many of you know, when you set up a company, you have to treat it as such. You can't simply treat it as your alter ego. There must be a separation between you personally and the company. For example, you have to treat the assets of the corporation as separate assets and not as your own. You can't use corporate funds to pay private debts. You also need to keep separate corporate books. And importantly, you need to follow the corporate protocols such as making filings, holding meetings, issuing stock, and conducting the business by resolution, for example, by holding board meetings. The failure to do these things, the court may consider to be abuses of the privilege of incorporating, and they may say that fairness demands that the shareholder be held personally responsible. Another misstep that can lead to piercing the corporate veil is undercapitalizing your company. There's no absolute test for when your company is adequately capitalized, but at its most fundamental, you need to make sure that you have enough funds to pay your debts as they become due. Put another way, you have to put enough capital at risk in order to cover your prospective liabilities. Now, when you're trying to consider how to satisfy these requirements, you should consider the scope of your contemplated business to determine what are the foreseeable risks and what are the potential liabilities. Now, you should note that you can't prove solely by showing that the company is now insolvent that it was undercapitalized. But if insolvency were to occur shortly after you'd formed the company, that's an indicator that obviously the company was undercapitalized to begin with. And the last misstep that I wanted to address that could lead to piercing the corporate veil is the most obvious one, and it pertains to fraud. And it would be any circumstance where avoidance of personal liability operates as a fraud on creditors or other third parties. And an example of this would be creating or dissolving a company to defraud your creditors. And a more specific example is, let's say that you have a covenant not to compete with X third party, and you can't avoid that covenant not to compete merely by forming a company and having that company compete instead. I should note here that actual intent to defraud is not always necessary, and it can be as little as constructive fraud, or if the court determines that an inequitable result would occur. and they could attribute fraud to your actions. I also want to note a few other areas that can subject you to personal liability. And you may have liability based upon your position at the company. For example, corporate officers and directors, as well as LLC managers and general partners, they owe fiduciary duties to the company and to its stockholders and owners. And if you were to breach that fiduciary duty, you could expose yourself to liability in that sense. Another way to expose you to personal liability is through your own personal actions. Let's not forget that if you were to act inappropriately in a personal manner, simply because you own a company does not protect you from personal liability. If you were to engage in illegal activity or something negligent, you could be held personally liable. One other important area of personal liability pertains to personal guarantees. Particularly for new business owners, they're often asked to give personal guarantees. For example, anytime that you're trying to secure a lease or if you're trying to secure a loan, that lessor and that lender is likely to ask you for a personal guarantee. In that case, not only are the assets of the company at risk, but also your personal assets. And I would definitely encourage you, if you're considering signing a personal guarantee, to give it a lot of thought and to consider the fact that your personal assets will be at risk. And the last one that I wanted to mention, another area of personal exposure, pertains to dividends and distributions that may be made in violation of law. Under Arizona law, you can only give a dividend if you have surplus earnings in your company. In other words, if you don't have enough funds to cover your debts as they become due, and you were to give a dividend, those directors who authorize the dividend could be held personally liable. So another area to be careful in terms of personal exposure. Now, before I turn things back over to Lowell, I wanted to preview some of the more sophisticated legal structuring of a business that you may want to consider. Now, in addition to the protection that can be afforded to your personal assets by forming a company, you can also protect the assets of the company by forming related entities, subsidiaries, or affiliates. In addition to the protection that can be afforded you personally by forming a company, you can also insulate different businesses by forming separate related entities. For example, if you were in the business of molding plastic parts that were included in, let's say, a water bottle, and with your company you decided that you wanted to start creating plastic parts for medical devices, which obviously involve a lot more risk, you may want to consider forming a separate entity in which to commercialize the plastic component parts for medical device. And therefore, you insulate the risk associated with that line of your business to one entity, and you leave the plastic where you make for water bottles to the previous entity. Similarly, if you were to want to take a portion of that business overseas, you would likely want to set up a separate entity in which to operate that overseas entity. The same rationale applies for different asset types, that you may want to create a different entity to hold different types of your assets. And it's a way to spread risk. What's very important to keep in mind here is that you have to respect the fences that you create between these entities. You don't want to pierce the corporate veil. And the same rationale that applied to piercing the corporate veil to access your personal assets, the court can apply to access the assets of some of your related entities. For example, if there were wrongdoing with respect to one of your entities, and that entity was undercapitalized, or you weren't following the proper corporate formalities, the court may decide that they can access the assets of the other entities, including the parent entities and any affiliates. So you'll want to make sure that you're respecting the fences between those companies. For example, if it were determined that you had undercapitalized one of these companies, the court may decide that they can access the assets of your related entities because that one wasn't sufficiently capitalized. Now, there are some tricky issues that arise when you're using the same personnel for multiple entities. For example, if you have one tax and accounting department that handles the tax and accounting issues for all of your related entities, it can be difficult to respect the fences. And so for those types of issues, we certainly encourage you to talk to a lawyer and get some counsel as to how you can make sure that you're properly respecting the fences between your entities.
When starting a business, there are various entities to choose. We'll be discussing C corporations, S corporations, limited liability companies, commonly referred to as LLCs, and to a lesser extent, limited partnerships and limited liability partnerships. At the outset, a core reason for choosing one of these entities is to protect your personal assets to the extent possible in the event of business failure. If you do nothing and operate a business as a sole proprietorship, there's no liability protection in such arrangement. If you get a judgment against you and that judgment is in excess of the value of the assets in your company and the insurance that you may have, then that judgment could attach to your personal assets. The same result can occur when two people get together, don't form any form of entity. They probably have formed a general partnership. Same result if there's any judgments or problems with business failure. This time around, though, if one person has more assets than the other, there's a concept of joint and several liability. And what that means is the person with the most and deepest pockets may suffer yet a deeper loss. Tax treatment is always an important consideration when starting a business. A C corporation exists as a taxable entity in its own right. C corporation pays corporate tax at the federal level. The shareholders also pay individual taxes on the dividends that they receive. Losses and profits are not passed through. As a consequence, a C corporation may not be a good choice for many beginning businesses where substantial losses may be expected to be suffered in the early years. A limited liability company, however, is not taxed as an individual entity. A limited liability company does not pay federal income tax at the entity level. Instead, profits and losses are passed through to the individual owners of the LLC. S corporations usually have the same type of tax treatment. For those of you familiar with angel and venture capital investing, you're probably familiar with such terms as convertible preferred stock, preferences on dividends, on liquidation. If you're looking to raise capital and bring in investors that are going to be treated differently than perhaps yourself, the S corporation probably isn't the entity that you want to use. S corporations are limited to the amount of shareholders, 100. They're limited to the amount of classes of shares that you can have, only one. You can have voting and non-voting, but that's pretty well it. There's also a limitation with respect to the type of investors that can invest in a S corporation. Non-U.S. residents, certain types of trusts, even a C corporation normally can't hold an interest in an S corporation. So if you're going to have investors such as venture capital investors who come in at a certain stage of corporate growth, this type of entity won't work because usually the later money that comes into your corporation will have rights and preferences attached to it. The general consensus is that a C corporation provides the maximum degree of flexibility in terms of types of securities and number of holders. The C corporation is the traditional vehicle for the country's largest corporations, which can have thousands of shareholders and complex capital structures. Corporations that are maintaining and in a position to raise institutional capital likely will be C corporations. They'll likely be incorporated in Delaware. And if you see companies on a public stock exchange, they're likely a C corporation, and most are incorporated in Delaware. However, the costs of a C corporation can be expensive. The tax considerations are more complex. Some of the more popular jurisdictions to incorporate in, such as Delaware, have a cost associated with doing business in Delaware. It's called a franchise tax. For large corporations, that franchise tax can be as high as $100,000. For the wary who do not plan appropriately, even small businesses can attract a large franchise tax if not properly organized. There are tax planning opportunities with respect to self-employment tax in connection with each of the entities that we're looking at and discussing. Self-employment tax is a tax on Social Security and Medicare taxes for individuals who work for themselves. The owner of a C corporation, for example, can avoid the payment of self-employment tax by not taking salary from the business. However, this strategy may not always work. Payment out of earnings as salary is a principal way of owners of a corporation avoiding double tax of dividends. Tax analysis and tax planning with respect to the different entities should be carried out with a CPA. As previously mentioned, the S corporation is the most restrictive of the entities by virtue of it only being able to have one class of shares. As a consequence, the C Corp and the limited liability company provide much greater flexibility in how profits of an entity are distributed. For example, a typical venture capital organization will make an investment in a company or a corporation. They will want preferences on dividends, preferences perhaps on return of capital, preferences upon winding up. The C Corporation and the LLC both are flexible in allowing these venture capitalists to have these type of priorities. You don't find that in the S Corporation. We haven't talked much about limited partnerships or limited liability partnerships. Suffice it to say that most things that can be accomplished with a limited liability company can also be accomplished with a limited partnership. But the LLC is a newer entity, and the limited partnerships nowadays are really used for pools of capital, venture capital funds, or real estate deals. Finally, with respect to annual filings and costs, C corporations have to make filings with state organizations on an annual basis and upon incorporation. LLCs and limited partnerships, however, don't normally have the annual filing obligations. But quite frankly, this shouldn't be a determination when utilizing a choice of an entity. The filings are not complex and they're not expensive. The LLC probably has the most flexible management structure. The LLC is owned by its members. The members can manage the company. The members can appoint a manager to manage the company. The LLC can also have a board of directors, very similar to what we see in C corporations and S corporations. They can appoint officers. The C corporation, however, is somewhat less flexible. The statutes set out more of how a corporation is governed. The shareholders elect a board of directors. The board of directors are responsible for the governance of the entity, and the board of directors elect officers who oversee the day-to-day management of the company. The corporate statutes also assign more duties with respect to those respective roles. Equity options are utilized by owners of businesses to incentivize senior personnel and others to be rewarded by the growth of the value of the corporation or the LLC. Therefore, it is expected that such persons are incentivized to work hard, meet the corporate objectives, and ultimately contribute to the growth of the entity. There are incentive options available for all of the types of entities that we discussed. However, with the differing options, there's differing tax impacts. Don't consider setting up a plan unless you've discussed this concept with a CPA or a lawyer.
After you've decided what type of entity works best for your business, there are some certain initial steps that you'll want to take to form and to establish the company. And we're going to go through those in turn. The first is, once you've considered what name you want to use, you'll want to check to make sure that that name is available. And you can do that by going on the Arizona Corporation Commission website. They'll be able to tell you if there's another entity that already has that name or if that name were available. The other thing that you need to do is to prepare and file certain documents. And it depends on the type of entity that you're using. It will either be articles of incorporation or articles of organization, for example, if you're an LLC, or a certificate of partnership if you're a limited partnership or a limited liability partnership. And those forms, template forms for those filings can be found on the Secretary of State website or the Arizona Corporation Commission website. And we've provided those links for you to use for your reference. The other thing that you'll need to do is once you make those filings, you'll need to publish notice that you have formed the company and that you have made those filings. In addition, you'll want to obtain an EIN, a tax identification number for the entity that you formed, and you can do that by applying to the IRS. Similarly, if you've decided to go with the S Corp entity, you'll also need to file an S election with the IRS. Now, the most important of these steps I'm going to address here last, which is preparing internal governing documents. And those depend on the type of entity that you've decided to form. But as you can see, with respect to the C Corp and the S Corp, it involves bylaws, board consents, stock subscription agreements, and certificates. And then, once again, depending on the entity, you'll have a different kind of owner's agreement. And that consists of either a shareholder's agreement, as in the case of a C Corp or an S Corp, or it would be an operating agreement in the case of an LLC, or a partnership agreement in the case of a partnership. All of these owner agreements are to be executed amongst the owners of the entity. And even though there's variances among the different types of entities, consistently throughout, these agreements address these types of items. Whether there are different classes of equity, it indicates who makes the decisions, who has authority to act on behalf of the entity. It addresses who has voting rights. It also addresses things like restrictions on transfer. If you want to make sure that owners can't transfer to persons that you don't know, for example, you could put restrictions in these agreements that would prohibit them from doing that. Similarly, you can put in place what are called rights of first refusal or co-sale rights, which are also a form of restrictions on transfer. A right of first refusal would say, if you, as one of the co-owners, wanted to sell your stock to someone else, first you have to sell it to me, the other co-owner. And if I choose not to buy, then you can sell it to someone else. Co-sale rights are similar in that if you, as an owner, wanted to sell to someone else, and I gave you permission to do so, but then I had a co-sale right, I would be able to join in the sale of those shares by you to the third party, and that would be a co-sale right. There are lots of other aspects that are addressed in owners' agreements, and once again, we encourage you to consult with an attorney at this point to help you in preparing those documents. As you recall, earlier in our discussion, we talked about the principle of respecting corporate formalities, and one of those formalities is keeping separate books for the company. And I wanted to spend just a minute addressing what types of records you should be keeping for your entity. And it varies a little bit depending on the type of entity, but principally, many of these things are the same. A corporate minute book for a corporation or an S-corp would have things like the articles and the bylaws and the owner's agreements that we just discussed. It would also include any meeting minutes of the board of directors or stockholders, or any actions by written consent. In that book, you also want to keep the stock ledger so that you have a running tally of all of the people who own stock or equity in the company. Typically, we also like to include in that book any material agreements that you have, such as your lease, so that you have them all at a ready, available place. And lastly, you'll want to include in there annual reports. As Lowell had mentioned earlier, this is a requirement that all corporations file annually. And if you keep it in your minute book, then you're more certain to make sure that you've complied with that annual requirement. When it comes to LLCs and partnerships, I also suggest keeping some kind of a minute book or corporate book. And in that book, you would keep the original filings, which are the articles of organization or the certificate of limited partnership. You would also keep the owner's agreement, which is either the operating agreement or the partnership agreement. And with respect to partnerships, you can include in there the annual filings that are required.
Next, we're going to talk about capitalizing your company, raising money. So who is it that provides new business with its initial capital? It's you, the founder. And who is it that provides money when the original money is no longer there? It's you, the founder. Maybe now you're looking to your friends and family, close friends, close family. We call it love money. Eventually, once you get to the point where your business plan is starting to be advanced and you've funded the company to a certain extent, there are other organizations available. Angel investors usually are in all communities. They may form clubs or simply be available as a resource to you. Angel investors are usually high net worth individuals. Many have expertise, perhaps in the area that your company needs. Angel investors will provide two things. One, capital, if they like your project. Two, expertise in order to help you grow your company. There's also other organizations like the Arizona Innovation Center, incubator organizations, accelerator programs. There's government loans, but no common loans from the government usually mean that you will be writing a personal guarantee. As Angela said in the past, it's always good if you can raise capital, debt or equity, without having to sign a personal guarantee. But one note to focus on is you have to put your own money into the corporation or the company because it's very difficult to go to a third party and ask them for money if you don't have the so-called skin in the game. Securities laws are very complex, but very important and cannot be ignored. Here's some of the problems if you ignore securities laws. Oftentimes down the road, it can cause the investment to be unwound. People who invest in your company, if you haven't done it correctly, can exercise a rescission right, which means they get their money back. And if you don't have the money in the corporation, that creates problems for you. Oftentimes, if securities laws haven't been attended to early in the going, and you've grown your company to the point that you attract institutional capital, that may bring an end to raising that capital. Oftentimes, violations of security laws are brought to light when it comes time to sell the company. If there's too many problems, the buyer can walk away. So, ever so briefly, what laws are triggered with respect to the sale of a security? And this isn't a legal definition, but a good way to think about it. If you want to sell your stock to a party that isn't going to be involved in active management of the company, that party is a passive investor. You have to think about securities laws. You start from the premise that when you sell a security to this passive investor, you basically have to undertake a registration statement, which is one of those documents that public companies have to prepare. Now, you know that that's not practical, but then you have to go through an analysis to find an exemption from the registration statement requirements. And the way you do that is you have to go and look at federal laws, laws of the state in which the investor is located, laws in the state in which you are located, and don't expect that there's always uniformity. Now, this is really technical, but one term that you should think about is accredited investor. An accredited investor is an individual who either has $1 million of assets, you don't look at the equity in the home, but who has equity in the home nowadays, or an income test, $200,000 for an individual, $300,000 with a spouse. If you only limit your sales to accredited investors, when it comes time to later raise capital with institutional investors, your life will be so much easier. It also means that you don't have various statutes, in most cases, that will tell you what type of information that you have to provide that investor. It simply leaves it to you, but you do have to provide that investor with all of the information that is necessary for that investor to make a reasoned decision with respect to the investment. At the beginning of a venture, you usually take on partners. It's very important to clearly define the roles and objectives of each of the partners and the roles and objectives of the organization. Pre-planning as to who's going to receive what portion of the pie, who's going to receive what salary, who's going to ultimately make decisions with respect to the corporation going in a forward direction, and what to do in circumstances where one person can no longer be a partner. It's important to sit down and document those agreements at the beginning of the process rather than later. And Angela's going to talk about some of those fundamental agreements.
The last objective of today's presentation is to address for you some of the basic agreements that every business must have. These are ones to consider as you're forming your company and will be important early on. The first are equity purchase agreements. This is the agreement pursuant to which people can invest in your company. So certainly you're going to want to have one of those in place with whoever you bring into the company, whether it be an angel investor, friends and family, as Lowell had discussed. The others are shareholders agreements or operating agreements, which we discussed previously. Also, you'll want to consider an equity option or a grant agreement. As Lowell had mentioned, these are ways to incentivize your employees, and you'll want to consider those early on as you're bringing people into the enterprise. The next on the list are confidentiality, non-competition, non-solicitation, and assignment of inventions agreements. And I know that's a mouthful, but that's actually referring to one agreement. And these are critical. These are what your employees sign. And this is a way to protect whatever they develop on behalf of the company so that they keep it confidential and so that the company owns whatever it is that they develop for the business. This is one you will certainly want to put in place with all of your employees right away. And it's one of those agreements that venture capitalists and other investors are going to want to see are in place before they'll decide to invest, because it's a way that you can ensure that you have that you adequately own everything that's been developed by your employees. The next on the list is a standard confidentiality agreement, and this would be something that's executed by a third party. And I encourage you, any time you're talking about your business with any third party, you'll want to put a confidentiality agreement in place. Even if it's someone you know well, someone that you've met in your trade circles, those people are competitors at times, and you'll want to make sure that you've put in place a confidentiality agreement before you share with them any confidential information. Next on the list are offer letters, employee handbooks, and employment agreements. These are pretty self-explanatory, but obviously if you're going to be bringing on employees, you'll need to have in place some kind of a letter. You'll want a handbook to make sure that you can control to a certain extent their course of conduct as employees of your company. Next on the list are independent contractor agreements. These are critical for early stage companies. When you're at a point when you don't necessarily have enough funds to hire employees, or at least a large number of employees, these types of agreements can be entered into as sort of a one-off. If you wanted someone to come in and to set up your computer system, for example, you could hire them as an independent contractor. They could use their own skills, they would obtain their own insurance, and they come onto your site and they do a discrete project. You'll find that you're doing that often, and you'll likely want to have a form of independent contractor agreement. The last two are when you really start getting into commercial sales and commercial business. You'll want to have a customer agreement or a supplier or vendor agreement. These are forms that you can put in place, terms and conditions pursuant to which you will work with your customers, pursuant to which you will buy and sell products. Oftentimes, we like to have a standard template that you can provide at the outset. Sometimes you'll find that that customer or that supplier or vendor wants to use their own form. But it's a good investment to have so that you know that you have terms and conditions that you're comfortable with, that your lawyer has vetted, and that protect you from liability.
So let's go back to the beginning. We had 3 objectives. Understand the advantages and disadvantages of the different types of entity available to your business and the appropriate entity or entities for you based on your business objectives. Understand the most common mistakes that a business owner may make in attracting personal liability with respect to the operation of his or her business. And finally, understand the critical contractual arrangements that a business owner should consider at the commencement of any business operations. So where does that leave us? A couple of tasks. If you haven't done so, what type of entity will you form and what steps will you take to ensure proper governance? Assess your team and partnership structure. What steps have you taken to pursue the right partnerships, and do you have the right agreements in place? Review the agreements list, create a plan of action, address any missing documents that may be appropriate for your venture. And one final tip. The more you reduce to writing and the less you leave to verbal arrangements, the better your life will be. Remember the story when we were in kindergarten and the teacher would say, tell a story to one person and pass that story on, and by the time it gets back to the kindergarten teacher, that story is misinterpreted horribly. Well, that's what happens to us when we don't reduce our agreements to writing. Time passes, people have different views, and oftentimes when it should be our most successful times in a business enterprise, it can be the worst. On behalf of Angela and myself, thank you.